I'm a volunteer with SCORE, and I'll just give you a couple moments of history of what's going on. SCORE has about 200 chapters across the U.S., and we have about 10,000 volunteers. We have a good group in LA, and we endeavor to provide webinars and mentoring free of charge. We're a group of active and retired entrepreneurs and executives. We used to be all retired, but now we've got other people that are still working that are joining us in this effort. So we encourage you to take advantage of our services and to stick with us over the life of your operation. We create success stories. We have face-to-face interviews, emailing, counseling, business workshops, and various resources on our website. A real popular one is funding resources, where you can learn what's out there in the world of loans and grants. And we are lucky to have a lot of great people join us in presentations. Our presentations include starting your own business, creating a successful business plan, financing your business, marketing, franchising, creating an online presence, promoting and protecting your invention and others, and trademarks, as we'll discuss today. Thank you all for coming. Do hook up with a mentor, like us on Facebook, and tell others about us. We are here 5 days a week. I'll turn it over to Justin. Thank you, Justin.
All right, thank you very much. I just want to take an opportunity and say thank you to SCORE, and thank you for allowing me to share today. This is my opportunity to give back. SCORE has helped me tremendously along the way, and I have the utmost respect to SCORE and the SBA as well. So we're talking about trademark law essentials, protecting your brand and business. If there's anything that you take from this presentation today, I just want you to remember the formula, the magic formula, okay, of the rights equals the power, and the power is the ability to monetize. The rights, your legal rights, is your ability to have power, have ownership, have control over certain properties. And that's your ability to monetize, to have security, to make a livelihood out of your mental labor. Trademark is an area of law that is encompassed by the subject of intellectual property. Intellectual property is the subject that protects your mental labor, okay? It is made up of copyright, trademark, and also patents. And there's an overlap in intellectual property. It's important to work with competent legal counsel along the way so you're informed of your rights and what is valuable in your intellectual property portfolio. But the most valuable asset in your intellectual property portfolio is most likely will be your trademark. That's your brand. That's your business reputation. That's your goodwill. And what exactly is a trademark? The definition of a trademark is a distinctive mark, signature, or device affixed to an article or its wrapper, package, or container to show that it is marketed, manufactured, grown, or selected by a particular person, firm, or corporation. There's a term of art that we call a insignia. It is a mark. It is meant to protect not just the producer, but the consuming public in order to make quick buying decisions. It also allows the service provider or the producer to protect against fraud and counterfeit, okay? It's based on your reputation, your commercial identity. It reduces the customer costs and purchase decisions, and it encourages the production of quality goods. It gives the guarantee of product authenticity, that it's genuine and it's of good quality. It could be very well the most valuable asset in your intellectual property portfolio. 3 basic functions of a trademark. It indicates the source or the origin of a product or service. It guarantees the quality. It allows for quick buyer decisions. And it distinguishes your brand, your business from competitors. It sets you apart. And I'll try to address any questions at the end because I have a few slides and I'd like to get through it. And the purpose of this presentation is to impress upon you the legal knowledge, because again, the rights is the power and the power is the ability to monetize. I want you to be informed on your legal rights so that you can maximize the value of your business. Again, what is a trademark? There's a few different kinds. It could be a symbol, a word, a slogan, a phrase, a logo, a font style, a scent, packaging, sounds, or a color scheme. A design mark such as the NBC Peacock, the font style such as Coca-Cola, the sound such as the MGM Lions Roar. Anything that is identifiable, the consuming public can recognize as your brand, you can attempt to have it trademarked. It is quite broad what a trademark is defined as. Because business involves commerce, the federal government can regulate based off of the Commerce Clause of the Constitution, and they have passed law, the Lanham Act, which is also known as the Trademark Act. That gives the federal government the ability to have trademarks registered. It allows them to regulate it. They have passed codes regarding trademark regulation, and they define trademark quite broadly. Any word, name, symbol, or device, or any combination thereof. It's not restrictive. It basically covers anything capable of carrying a meaning. So let's talk about what is not a trademark. Domain names generally are not trademarks. They're determined to be more descriptive. And you'll see there's different levels of trademark. There's different levels of strength. There's a strong mark, there's a weak mark, and we'll get into that. But weak marks are those that are descriptive. And domain names are generally considered descriptive. However, in the law, there's always certain exceptions. Booking.com, for example, that's one domain name that has garnered enough public perception to be recognized. And there's also ways to get around it. And this is another example why you should work with competent legal counsel so you can find ways to protect your brand, your business. Perhaps you create a logo mark with the domain name and you put it on a product or you put it on a website. You show that you're using it in commerce in a different way. You can still have the domain name protected, but in a different form of legal protection, okay? Business names, again, similarly, are considered to be descriptive. If it is a descriptive mark, that is, it's describing the subject, such as a name, it will not be able to have strong trademark protection. It will be weak and it will probably not be able to get registered and placed on the the United States Patent and Trademark Office registry. And we'll get into that further as well. But again, there's other forms of protection in terms of business names. First of all, you should register your business with the Secretary of State, have it as a formed entity. And then if people are using your business name, there may be another legal theory such as unfair competition. They are passing off your good name, your business name, your reputation as if it is sponsored to theirs. They're passing off on your business reputation. And that's another different legal theory. But trademark generally does not protect business names because they are descriptive. Same thing with an ornamental design. It has to be a identifier, right? And for a trademark to be applicable, generally it has to be on packaging or on a tag, okay? It has to be an identified source. It's about identifying the source of the good or the service. Product features are not protected by trademark. Instead, it's a different theory, trade dress. It's a different legal theory to go on. The difference is the damages that are recoverable. You can even have trade dress registered with the United States Patent and Trademark Office just as like a trademark, okay? They have federal registration system for trade dress. Trade dress is not protected by trademark because it would present an unfair competitive advantage. It cannot be the product itself. Consumers must associate the specific feature with the particular manufacturer, okay? That would be protected by trade dress, a different legal theory. So functionality as well is not protected by trade dress or trademark, okay? For example, the feature of the product is not protected if it serves a functional purpose, is too much of a descriptive characteristic. It would again provide for an unfair competitive advantage. A functional purpose would be such as the handling or the storing. Now, scent, for example, take perfume. Scent is not protected if it is considered a function of the product that you are selling. However, with perfume, perhaps there may be a different way to protect it with another area of intellectual property. Remember, we discussed that there are overlaps. So perhaps copyright may be the better form of protection for a perfume. Although copyright does not protect recipes because it's considered not to have originality, perfume has been considered more artistic. So there's argument to be made that there is some elements of creativity in order to protect it with copyright. And if you want to get around this, okay, it would be better to just create a mark, a logo, and put it on the packaging. Again, trademark protects the identifying source. It's more about packaging, it's about tags, it's about allowing the consumers to make quick buying decisions so they know that the good or the service is of good quality. The key here for trademark is that it has to be unique. Unique marks are strong marks. Trademarks must be distinctive, that is coined, arbitrary, fanciful, and suggestive marks are considered inherently distinctive marks. They are strong marks. There's different levels of marks, and they will be registered on the principal register when you file for a trademark application. And some practical how to file an application, you can look up the Trademark Electronic Application System, TEAS. It's very user-friendly, and they have very good videos on nuts and bolts on how to use their application system. Distinctive, unique marks are more powerful, all right? They're strong marks, and they're put on the primary register, the principal register, maintained by the United States Patent and Trademark Office when you file for a trademark application with the Federal United States Patent and Trademark Office. There's the principal registry, and there's the supplemental registry. The supplemental registry are those that are not quite as strong marks, that they're more descriptive, they're more not quite have garnered those distinctive qualities to be recognizable. But there's still potential. They're still in the works. They would be placed on the supplemental register. It still gives you some advantages in which it allows you to use the symbol of the circle with the R, which gives the public notice. And you'll still be placed on the USPTO database that can be used for trademark searches to put competitors on public notice. It's about notice, priority, first in time usually controls, all right? Different categories of trademarks. Again, there's a scale. There's more strong marks and there's weaker marks. There's arbitrary and fanciful. Those are your unique marks, and we'll get into examples for each one. Suggestive, they're medium. They have to acquire secondary meaning. And there's descriptive, which are weak, and generic, which are afforded no protection. The last two, descriptive and generic, those are the marks that lack distinctiveness. It's about being unique and recognizable. Now, before you choose your trademark, I would do a trademark search, okay? And that you can conduct a search on the Trademark Office. TES is the Trademark Electronic Search System. That is one place to start. And then you can also do an online search. And then you can even take it further and search government databases. The state Secretary of State's, the Secretary of State websites many times have registries as well for state trademark rights. And we'll get into that further, the different types of rights. There's common law state rights and federal rights. And there's differences. And the main difference is the type of damages you can recover. My experience is as a litigator, and I've done trademark infringement cases, and it's about compensation and what you can recover, damages. There's a lot of benefits to trademark registration, and I will come back to that. Different types of mark. There's the arbitrary or fanciful marks. These are the ones that are unique. They have the most strength. Fanciful mark is an invented word, a word such as Exxon, Kodak, Polaroid, Starbucks, Xerox, Haagen-Dazs. They bear no relationship to the underlying product. They're completely made up. They're invented. They're fanciful. Then there's also arbitrary marks, such as Apple for computers. They bear no relationship to the product. You can use Apple for computers because it's arbitrary. You could not use Apple for a product that was an Apple. It's descriptive, it's too generic. You wouldn't get protection for that. You cannot get a monopoly over that. Another example for arbitrary is Allstate for insurance, the Nike swoosh symbol. These are prima facie registrable. It's based on uniqueness that will get you on the primary register. Suggestive marks. Those are ones that you have to use your imagination to understand the connection. It doesn't specifically describe the good. Examples include Whirlpool washing machines, copper tone suntan lotion, Ivory soap. These are brands that have recognizable qualities. They have garnered distinctiveness. They are immediately recognized with the producer. Descriptive marks, again, are weak marks. They must acquire secondary meaning. That means you have to use it for an extended period of time, at least 5 years in commerce, so that the consuming public starts to recognize it as your brand. There's a test. Does the primary significance of the mark identify the source of the product rather than the product itself? It's about the producer, the manufacturer, the service provider. An example is Holiday Inn. Generic terms. Again, an Apple mark could not be used for a product of apples. It's too generic. You cannot have that type of monopoly. The law will not allow you to have it. How do you acquire trademark rights? I will say this. The best thing to do is start using your brand, your mark in commerce. Start using it. That is where you gain value. That's when you start to build your recognition and you start to acquire common law rights, okay? Just by using your mark in commerce, you acquire trademark rights. They're common law state rights. They're not the strongest rights to proceed on if there's a dispute. You rather have federal rights, okay? So first, to use the mark in commerce, priority in time is a factor. Assuming you have a distinctive mark, you can acquire rights by using it in commerce and then also register it with the United States Patent and Trademark Office. Just by using your mark, you acquire common law trademark rights, but they're not very strong rights. They're limited. They're restricted in territory, just your locale where you're selling your product or your service. And it must be used in the course of business. Again, it's first in time, but it's restricted in geography. Again, you're restricted. You can't even try to get the neighboring local business to stop infringing based on common law trademark rights. They're very local. They're very limited. Now, if you're doing business on the internet, now you're doing interstate commerce just by the fact that you're on the internet, and you're subjecting yourself to federal regulation, and you should register your mark with the United States Patent and Trademark Office. I would always suggest that you register your mark with the Trademark Office. You only acquire rights. So the federal government has the ability to regulate trademarks through the Commerce Clause of the U.S. Constitution. They have passed the Lanham Act, which is the regulation for trademarks. And it is basically a trademark registration is a grant by the U.S. government of a right to exclude others from using your mark. The federal government regulates trademarks, again, because of their policy of protecting the consuming public. They believe it allows the consuming public to make quick buying decisions, and that's good for the economy. So that is one of the overarching policies in the federal regulation of trademarks. When you register it with the USPTO, you get certain benefits. You get exclusive nationwide trademark rights. You get presumptions, powerful. You get legal presumptions. You have the presumption that the mark is valid. You have the presumption of ownership. And these are requirements that you must prove if you're going to succeed on a trademark infringement lawsuit. You are required to prove that it is a valid, strong mark, and you have ownership of that mark. And by registering it, that relieves you of the burden of proving that, because you get certain legal presumptions. It's very important. And you get access to the federal courts to file your infringement lawsuit. The federal courts are more versed in these legal matters. It is a better venue. Again, if you don't file for registration, you'll be locked out of federal court. You'll be stuck to state court, and the state courts generally they're not well experienced in infringement matters. It's not a venue that is in your favor. For these business type disputes, the federal courts are a better venue for the most part, because you also get powerful remedies. You get legal enhancements at the end when we talk about damages. It also puts the public on notice. You get constructive notice of your mark. And first in time is a factor, it's a priority. We talked about enhanced remedies. For trademark infringement, it's treble damages. That's 3 times the amount of actual damages. The different costs, if it's malicious, you can also disgorge the defendant of all the profits that they made. And it aids you in registration in foreign countries. Many times, if you're doing international business, there's treaties. There's treaties that will recognize our trademark rights here in the United States. Or if there's not a treaty, sometimes you may have to take up defensive registration in those other jurisdictions. That's somewhat beyond the scope of this conversation, but there are legal ways that you can still protect your rights, your international intellectual property rights. And that involves treaties, and it also involves defensive registration. When you apply for a trademark, you can apply for the actual use application or an intent to use application. Now, the intent to use is really, again, just to establish priority, to put competitors on notice. It preserves your timestamp. It actually is not complete. In order to have a completed registration, you must use your mark in commerce, and you will be required to submit specimens to the United States Patent and Trademark Office. And that's basically how you're using your mark in commerce. You could take a photo of a tag, take a photo of packaging. Many times it may be a screenshot of a website. There's many different ways we can submit a specimen. And the actual use application, again, you have to submit a specimen, and it requires interstate commerce. You have to satisfy the interstate commerce requirement in order to apply for a federal trademark registration with the United States Patent and Trademark Office. A lot of times that is satisfied just by conducting business on the internet. Again, the intent to use application is not completed. There's added steps. It's really meant to just establish priority. It requires actual use still before registration is complete. It's not yet complete. The key here is, and as I said before, is to start using your mark in commerce. all right? The intent to use application will require some additional evidence that is a bona fide intent to use the mark. It's more than just an idea. It would require evidence such as sample products, business plans, or other type of business activities. I would rather see you start using the mark in commerce. Build the brand so that you can be registered and get on the principal registry. Again, the principal register is the register that lists the strong marks. These are the ones that are distinctive, that are unique, that are the ones that are arbitrary and fanciful, that are suggestive, and descriptive marks that have already acquired a secondary meaning. Descriptive marks, too generic. They're not going to be able to get trademark protection. They will not be able to be placed on the principal register. Once you get on the principal register, and if you're on that register for 5 years, you can have your mark determined to be incontestable. It's very difficult to challenge an incontestable mark. Also with the principal register, you can also submit filings to the United States Customs Service to prevent imports, to prevent counterfeit, international counterfeits from entering the country. So there are some very powerful benefits of the principal register. If you're placed on the supplemental register, which consists of descriptive marks that have not yet attained secondary meaning, you still have some benefits. You're still placed on the register. So on trademark searches, you will be listed so competitors can have notice. You can still use the symbol of the R with the circle around it. You can only use that symbol if you have a registration, the R with the circle around it. Now, if you have not applied for federal registration, you can still use the TM, but the R with the circle around it is reserved to only marks that have been registered with the United States Patent and Trademark Office. So it still provides notice. Now, some people may have a title. I've done a lot of work in the entertainment industries, and they want to trademark their title. Titles are not protected by copyright because they're determined to not have originality. Copyright protects creative expression of ideas in a tangible medium, but a title will not be protected by copyright. Now, titles for a single work are also not protected by trademark because they're determined to be too descriptive. They're inherently generic. Now, there are exceptions. Titles to a series of creative works, such as Harry Potter, all right? There's an exception to this rule, all right? And we can get around it by placing the title on some form of product. For example, a disc, a DVD, or even put it in the title and a creative logo on a website. Again, we have to attach it to a product. All right, it has to be on a product or a service, but titles alone are inherently descriptive and most likely will not get trademark protection. There are other theories we can go on. Again, the unfair competition law, mislabeling, misdesignating a product so as to confuse consumers, to pass off to as if you're sponsoring another business. That would fall under unfair competition law violations. And also, if it's a film, for example, there are associations such as the MPAA, the Motion Picture Association of America, that has their own evidence database that will register your title to serve as a third party, basically a third party witness in the case of any type of dispute. Doesn't give you any legal rights, but it serves as an evidence database. You can lose your trademark. It is good for 10 years, and at that time you have to provide a declaration of use, and there's also renewal fees. Now, the USPTO does not send out reminders. There are grace periods, however, but it just has to be on your radar. 10 years, you have to renew. Okay, so there are terms, expiration terms to your trademark. You can also lose your trademark rights also through abandonment, improper licensing, or a term that we call genericide. All right? Abandonment is that you stop using it for 3 consecutive years, or you've expressed an intent not to resume. And it can be inferred by the circumstances. All right? The key, again, is you must use your mark in commerce. You can also lose your trademark rights if you conduct improper licensing and assignments. That's why it's important to have your contracts drafted by an attorney so that you know what rights you are giving. Many times you may give what we call a naked license, and that will give away your mark so broadly that it's used no longer in a way that is attached to the product or the services. That's why in your license agreements, it's very important to have quality control standards. If you're licensing your mark or any type of your intellectual property, it's important to have quality control standards so that you maintain the value of your property, your intellectual property. Genericide. Now, this can happen. It's quite rare. It happens when the mark becomes so widely known, it loses its distinctiveness. Marks such as escalator, thermos, aspirin, nylon, post-it notes, cellophane, they have lost their distinctiveness. They have become so common in our language that they've lost their unique value. And if you're using trademark genericide, it's usually brought up as a defense, and the court will evaluate dictionary definitions, the use by newspapers and magazines, and also the attempts by the trademark owner to police its own mark. That's very important. That I have to enforce. You have a duty to police your own rights. You have a duty to police your trademark rights. You have to be vigilant in sending cease and desist letters if you are put on notice that there is potential infringement on your rights, your trademark rights. The law favors those who are vigilant. If you sit on your rights, you will have said to have slept on your rights, and you will forego your rights. So it's important to prevent others from using your mark so you maintain your value and you prevent genericide. It's a rare situation. It does happen, genericide. Trademark infringement. The key here is likelihood of confusion. It's about the consuming public. If you think another entity or a person is infringing on your trademark rights, okay, you have to assert your rights, and ultimately it may be a lawsuit for trademark infringement. And the test is the likelihood of confusion, whether an ordinary consumer is likely to be confused between the marks. It's about public perception. Infringing equals likely of causing confusion in the consuming public as to the source of the goods or as to the sponsorship or approval of the goods or services. If it's a service, it's referred to as a service mark. If it's a good, it's considered a trademark. I just want to make that distinction. But the test is the same, likelihood of confusion in the consuming public. And the court will analyze the similarity of the marks, the similarity of the goods or services, the similarity of the trade channels, and the extent of actual confusion. The most important factors are the first two, the similarity of the marks and the similarity of the goods or services. If the marks are very similar, if close enough in sound, appearance, or meaning, that's what the court will evaluate, the similarity. If you're using the same mark on completely unrelated product, it may not be considered infringement because this consuming public will not be confused if you're using two different products, all right? But there may be other legal theories to go on. And more widely known products, more famous marks such as Coca-Cola and Coach, they're registered in broad categories. It's virtually impossible to use on any product. They have that much brand recognition. We all know these brands, okay? The court factors the strength of the mark, the proximity of the goods, the channels, the trade channels, the similarity of the marks, the evidence of the actual confusion, and a lot of times this can be presented in court by surveys or any type of forensic type audits, but surveys are a lot of times presented as evidence. The marketing channels used, a lot of times it will be required to retain experts, expert opinions that can give testimony that will be helpful to the jury in determining these factors, is a lot of times required in infringement cases. And that's what make infringement cases very costly. Other factors include the type of goods and the degree of care likely to be exercised by the purchaser. That's what we call purchaser sophistication. The defendant's intent, the likelihood of expansion, the quality of the defendant's goods as compared to the plaintiff's goods, and whether the defendant's attempt to register was bona fide and in good faith. So there's many factors. There's no bright line rule. The court will have many factors to consider, and every case is dependent on its own facts. But it is the plaintiff's burden. You have the burden. If you're alleging someone's infringing on your mark, your brand, your business, you have the burden to prove that there is a likelihood of confusion that exists. And then again, trademark registration provides a lot of legal benefits and presumptions. You are relieved of the burden of proving actual ownership and that you had prior use of the mark. There are defenses to trademark infringement: classic fair use, what we call classic fair use and nominative fair use, and First Amendment. It's always a balancing act. We're balancing individual rights versus constitutional free speech rights, expression. And a lot of times the law is not meant to give someone monopoly, but to encourage expansion, to encourage more free speech. Classic fair use is when you are mentioning the mark. For example, there was a case against that sweet tart candy brought against Ocean Spray because Ocean Spray was using the term sweet tart in their ads. Sweet tart was unsuccessful based off of classic fair use defense. There was no consumer confusion. Again, the main element is protecting the consuming public. It's about confusion in the eyes of the public. Nominative fair use is when you refer to the mark when it's sometimes necessary to comment and reference another product. That's called nominative fair use. You're not directly profiting from the mark. You're only referring to it in the way that it's intended. And then there's also parody. This is not considered to be trademark infringement. It's considered to be protected by free speech, but it must be editorial, it must be artistic, it must not be just tied to commercial purposes. There must be an artistic element to it in order for it to be considered parody. Otherwise, you're just, again, palming off. You're passing off on the brand and gaining the value that's built in to the brand, and that would be unfair. But so long as there's artistic elements to it, it's protected by First Amendment free speech. Trademark infringement remedies. And this is why it's important to register your trademark, because you get special remedies based on the code, the federal regulation. You get the power to seek an injunction, which is a powerful legal remedy, and then also money damages. And with trademark registration, there is also enhancement damages, treble damages, if you register your mark with the USPTO. An injunction is an order by the court to stop doing something or to do something. It's quite a significant remedy because it's infringing on people's liberty. We're actually telling them that they must do something, and they usually and stop the infringing conduct. Monetary damages, you can seek defendants' profits, you can disgorge their ill-gotten gains, you can seek your actual damages. And that would require a lot of forensic auditing experts in order to give calculations. It can get very difficult. You can also seek to have your attorney's fees. You would have to file a motion for attorney's fees at the end of the matter. Only the prevailing party can have their attorney's fees paid. It is a fee shifting statute. In the United States, each side is responsible to pay their own attorney's fees unless by contract or there's a statute that grants the fee shifting. And for trademark infringement, it does shift the attorney's fees. You also have enhancement, treble damages. You can recover up to 3 times the actual damages. These are basically leveraging points that you will want to assert in when you police your mark. You let them know that the consequences can be quite significant in any cease and desist letters. There are also related causes of action. There's always ancillary rights. We talked a lot about unfair competition. There's also trademark dilution and trademark tarnishment. Now, trademark dilution requires that the brand is famous. It has to be well known. It's very difficult to succeed on a trademark dilution claim. It has to be a very well-known brand. Okay, the court will factor the degree of inherent or acquired distinctiveness, the duration and extent of use, the amount of advertising and publicity, the geographic market, the channels of trade, the recognition in trading areas, and whether the mark was registered. It's, again, trademark dilution is really only reserved for famous marks. Trademark tarnishment may be another claim you can proceed on. A lot of times it may be a fallback claim. If you can't quite satisfy confusion in the public, you may be able to fall back on trademark tarnishment in that it's portraying your brand, your business in an unflattering light. You may be able to assert that claim. And again, there's also the unfair competition claims that you're passing off unfairly, that you're gaining from the inherent business goodwill and value of another business unfairly. It is, again, based on the Lanham Act. There's 2 categories: false advertising and likelihood of confusion, again, is an element. To proceed under the unfair competition violations, it does not require a federal registered trademark. But the elements are similar. You still have to prove likelihood of confusion. So that is, we got through the slides. Perhaps if there's any Q&A. I see John has his hand up. Let me see if I can control. Hello, John, can you hear us?
Yes.
Yeah, do you have a question?
Yeah, you answered part of it, but I just want to know, and I know that a lot of these, it can be answered, it depends, but just how far down the line in the way of production and actual commerce do you need to get? Because you do have to show that it's out there, that it's being used, but you also don't want it, if you have like a catchy title or something that somebody could be drawn to, tempted to copy, they can make a big ado with it. And if they happen to have certain inroads that they give them greater visibility, they might try to claim first use. And so you don't want to avoid the vulnerability, but you can't jump ahead of time. So just can you give me a little bit better perspective of where in the process of research, development, production, and actual commerce, where you actually need to get the trademark protection in place?
Absolutely, great question. It may be a situation in which you may want to consider the intent to use application in order to preserve your notice in time, in order to place competitors on notice that you have an intent to use this brand. That will require additional steps, as I discussed, additional fees, an additional statement that you are in fact using the mark. The USPTO will hold you to actually take steps forward toward using the mark. But to loop it back, how much in commerce must you show? Not much. Look, if you have it on a product, take a photo of it. A product, a website, any type of depiction showing your mark on your product or your service, it should be sufficient. It has to be in commerce. It's just one sale. That's all you need. Maybe steps toward commerce would be sufficient. It's a very gray area. It does fall back on your specimen. What type of specimen are you producing? If the PTO officer will accept it, there is going to be office action on your trademark registration. They could bring that up, but they will evaluate your specimen. Does that answer your question?
I think so. I'm just thinking if there's like a hard launch and there's a lot of publicity and you're getting the name out there, you want to get a trademark with intent to use. But let's say your development time gets extended. When does it go stale when the trademark office says, you've had the intent to do this for 2 years?
Yeah, there is a time period that you do have to show your actual use. Your registration is not complete until you actually show use of your mark in commerce. I would say, though, it sounds like you have satisfied that. You don't have an intent to use. You are actually using it in commerce. You have a brand, you're making deals, maybe things have not been solidified, but you're doing commerce right now with your mark. I would say you qualify as an actual use mark. You just have to submit some specimen. And I would suggest an actual use application is far better than an intent to use. We can ask, I'll just go down the line here in no particular order. Steve, do you have a question?
Yes, I do. And thank you for this presentation. Yes, all I want to do is own my business name. It's super simple. And I went through the USPTO process and my application was rejected. I think it's been dead since October 2022 because I just left it by the side of the road. But all I want to do is own my business name. I'm lost as to why it was rejected. So if you could just shed some light on that, I would appreciate it.
Again, business names are not registerable. They're determined to be too descriptive. Okay, so you need some form of uniqueness. Okay, it has to be a mark. It has to be a logo. It has to be some form of distinctiveness. We did say it's very broad. It could also be a scent, but it can't be a function of the product. Now, I just want to put this out there. Scents can be trademarked. For example, you walk into a particular store, I think a Pandora, I'm thinking of another store. There is a unique scent in that industrial store. That is protected by trademark. All right, so it is quite broad, but it cannot be a name. It cannot be a name of the business. Now, there's probably a different way you can get around. Create something unique. It's about uniqueness. Come up with a logo, an artwork logo, maybe with the name of your business in a creative logo in which you can protect not only with copyright because it's a creative expression, but that you can also register it as a logo mark. And you can still try to prevent people from infringing on your business name by virtue of a logo mark. There's different ways we can protect your rights. Not to say if your business name is not already protected by other legal theories such as the unfair competition law. All right? A competitor just can't take your business name and start doing competitive business. Okay? There are still rights to assert. But the key is market dominance, recognition, uniqueness. I hope that gives you a general idea. Do you have a follow-up question?
Well, that does help to create a unique logo. That does help, and perhaps I'll work on that.
I will also say when people do logo marks, can also be protected by trademark. For example, I believe the PS brown and yellow combination is registered to protect with trademark protection, but it's a difficult trademark application. You have to have the colors identified in a palette. It's a very difficult application process, and you're only protected with those specific palette colors. Now, if you're doing a logo, I suggest submitting your logo in black and white to the USPTO, and that way you can have a claim against all different colors of any potential infringer may be using. Does that make sense?
Yes, it does. Thank you so much.
Okay, let's just continue with some questions. Claudia, would you like to ask a question?
Yes, thank you. Really appreciate this presentation, Justin. 3 questions. Will we get a copy of this recording? Will we get copies of the slides? And the question I really want to ask is, can you please go through the application process? What is that we need to submit, documentations, some basic information, how to prepare oneself for the application process? Thank you.
Good question. The application process for a trademark is quite tedious. Of course, it's open for the public to do it on their own. I do not suggest you do it on your own. It's a difficult application. You can do it online through that's the Trademark Electronic Application System. Before that, you can do a search to see if there's any marks already existing. You don't want to invest in potential litigation if there's already existing marks with stronger power in the consuming public. So you want to do a search. You can start with the Trademark Electronic Search System, TESS. You can also do online Google searches, and you can even go deeper into the web of a trademark search with local state Secretary of State databases for state registered trademarks. A trademark search can be endless. You can go down the rabbit of online, but you want to be thorough. So I would say at least do an online search and the Trademark Electronic Search System to see if there's any existing marks, so you don't want to invest in something that's already existing. And then you do your application through the Trademark Electronic Application System, TE, and you can do a trademark based off of international classes. All right, and the Trademark Office has developed a very extensive manual of classifications of goods and services. I suggest to go off of the international classes because they're easier to submit to the Trademark Office. You can do a customized application. It's a little bit more complicated, but I would go off of the international classes, and the Trademark Office will charge you per class. I believe it's $250 per a class. That's why you want to evaluate the classes to see if you can fall within one class in order to save expenses. It's a cost-benefit analysis, but many times the courts will hold you to your particular classification. It may serve you better to have a very expansive application with as many classes as you see that apply. I hope that answers your question.
Yes, but I was more interested in what are the actual questions, and do we need to prepare any sort of specific documentation? And then if you could please let us know whether we get a copy of the recording and the slides, that would be appreciated.
I believe you'll get a copy of the video, and I'm happy to provide the slides or include it with the video recording. The types of questions in your application will include, here, let me just pull one up. Let me see. I wish I had one that was redacted, but I think it's helpful to see an actual application.
Yeah, I just want to get a sense of whether a specific documentation need to be obtained from the city or anything like that.
No, nothing from the city, okay? It's just a database regulated by the federal government, the United States Patent and Trademark Office. You only have to submit your mark. You do have to make a statement that you are using it in commerce, and you have to submit a specimen of how you're using it in commerce. It could be a photograph of your logo with your product on it or your mark. Now, getting registration, again, there's different levels of strength, all right? Registration will give you presumptions when you're in court, but there's different strengths of marks. The most strong, powerful mark being those that are unique, all right? Not generic, not descriptive, very invented and fanciful. Uniqueness is key. I hope that further answers your question. Do you have any other specific questions?
I guess just wanted to know if when one registers trademark, do we have to have a logo or do we have to have a certain visual design attached to the trademark, or that's not necessary?
It helps because, again, the visual aspect gives it uniqueness, but it can be a particular font type. It could be a word mark, yes, but it must be very distinct or have acquired distinctive qualities, characteristics, secondary meaning. Again, Whirlpool washing machine, all right? It has to be recognizable, all right? If it doesn't quite have that recognition, that distinctiveness, it's not quite unique enough, it will be, once you can still register, but it will be placed on the supplemental registry until you show that you're continuously using it in commerce and you're acquiring distinctive recognition of your brand, and an amount of time, 5 years on the supplemental registry, and then you'll get lifted to the principal registry. And the principal registry are those that are strong marks.
Thank you so much, Justin. Really appreciate your answers.
I'd like to maybe just show, okay, here's a draft, and I think I'll just show what it appears like. So you do this all online. You can see this was a standard character mark, all right? It was a name, all right? A name of a business, all right? 4th Avenue, antioxidants, probiotics, and no sugar, all right? And then there's other ways when you register, you can disclaim certain parts of the marks so that it doesn't get rejected for being too generic, all right? So there are ways you can submit it. You'll see these are the classifications. We applied in International Class 30. It was more of a coffee type business, a juice bar. But you can see these are all classes that are already identified by the Trademark Office on their International Class Manual. They touch upon it. You just want to, but they're all within International Class 30, so it was only one filing fee of, I believe, $250 per class. All these areas are within the International Class 30. Now, filing basis, I think he was Section 1B. I believe this was an intent to use application, which, again, it's not complete. We have to establish more evidence. These are the classes continuing. We try to pick as many classes as many areas within that classification as possible. All right, continues on. Actually, we picked 2 classes, 030 and 043. I believe there's about 250 different classifications, and they all have many different areas within the classes, such as you see all these. Okay, so yeah, we made a disclaimer here because these was too generic, not just to the antioxidants and probiotics and no sugar, but you put it together with the 4th Avenue, with those other terms, you have something more unique. All right, it's all about presenting something unique, and that's really the application. You have to submit and this was our specimen. No, that was the standard character mark specimen. This has not provided a specimen yet because it's an intent to use, and we have an added step to submit a specimen and a statement of actual use. Does that make sense?
Yes, it does. Thank you.
Let me go back to, there's more hands. We have a few more minutes. Let me look at the chat as well. All right, let me see, how do we go here? Ray, would you like to ask a question?
Yes, please. If a trademark or logo has been in use for a number of years but has not been registered, do you still need to register it, and are there any repercussions one way or the other?
I would say yes. You must register your mark. All right, it's not required. By using it, you've acquired your common law state rights. You can still get into state court. Again, I think you're at a disadvantage for these type of infringement cases, and you are not availing yourself to the protections and benefits of performing trademark registration with the United States Patent and Trademark Office. You get the presumptions, you get the special remedies, You get the damage enhancements. You need to register your mark, all right? Especially if you've been in business for a while now. You've acquired.
And approximately how much is the fee to go to an attorney and have them do it?
They vary because, again, trademark, we took a look at a sample trademark registration.
That's about 41 pages.
Yeah, some registrations can get a little bit more complicated depending on what you're trying to protect. If it's a standard character mark, if it's a special character mark, a logo design, it depends. We can discuss more.
Yeah, it's a logo design.
Yeah, we can definitely discuss more. That's a little bit more of an easier application, a logo, because it's inherently distinct. It's artwork. Now, with logo designs too, you should also be mindful of copyright infringement because it is considered a creative artwork, a creative expression. Again, there's that overlap of intellectual property. There's different forms of protection. Sometimes you can register it with multiple forms of protection, copyright and trademark. Patents are a different ballgame. Patents protect inventions, processes that do not occur organically in nature. Something that there's an added function to nature that has developed a process, and that's what patents protect. In order to register a patent, you have to work with a specialized attorney that has a background in mechanics, engineering, and biology. But I can still do patent litigation, patent infringement, just not the registration process, which is known as patent prosecution. I just wanted to throw that in. But back to your question about costs, I generally like to do a deductible fee consult for a smaller fee that would be credited toward the further services, just to get an idea of what you need done, because trademark registrations can vary across the board. I would not suggest that you do the Google search and click on the do-it-yourself trademark registration that you see that pops up at the beginning.
That was my next question.
Yes.
I didn't know if we try to do it ourselves, so then that service is not available through SCORE.
I try to point you in the right direction. And again, I'm all about knowledge. And the purpose of this, again, was not so much to be practical, but I wanted to point you in the right place for the practical steps of registering your trademark. And I would say explore the USPTO website. They have a very good video series, the nuts and bolts of trademark registration, that can help you, walk you through the process. It is a difficult process. It's a complicated process, all right? But again, the purpose here is for you to be informed. I wanted you to know your rights, and I want to bring it back to the beginning. If you just take this one formula, rights equals power equals ability to monetize, all right? So just be informed about your trademark rights. Protect them, all right? You can do it through the Trademark Electronic Application System. I'm not here to solicit business, but it is a service that I can assist with. But I'm all about everyone being informed. And the USPTO website has a great video series. Very entertaining as well and very informative. Does that help, Ray?
We'll see. Thank you.
Okay.
I gather then that means it's very expensive, it sounds, but thank you.
They're some of the more expensive application services. Copyright being a little bit more efficient with the Copyright Office and dealing with their database. The Trademark Office is a little bit more strict, and it's because you're dealing with commerce. The federal government does take commerce very, very strictly, because that's where they get their power. It's based off of the Commerce Clause. That's their ability. That's their power, is to regulate commerce. And trademark has to deal with commerce. Any other questions in the chat? Let me see.
Thank you.
Thank you, Ray. Yuri?
Yadira. Hi, how are you?
How are you? Thank you.
Good. Thank you for the session. I applied for my trademark in August of 2021, and I just got it this year in June of 23, so it was over 18 months, almost 2 years to get it. But my question is, now that I have it, do I have to go back and change my logo and all my paperwork to have that R with the circle?
No, it's not required. It's not required, but you are permitted to use it. It is a benefit. It is a matter of preference, stylistic preference if you want to use it, but you have the ability to use that symbol.
Okay. And then you mentioned about it is my responsibility to do the policing to make sure that no one uses it. But back to that question of having the R, but even if I don't have it, I still, I guess, how would that person know that they're using somebody else's that's already trademark if I don't have that R with the circle on my logo?
You have to notify them. That regards providing them notice, usually a letter, an email, but you have to take steps to notify it. And I would also say, do not give something that you do not keep a copy of yourself. So if it is by written correspondence, make sure you keep a copy of it, and I would send it by certified mail so that you have tracking. But you have a duty to police, and that means you must take affirmative, assertive steps to bring to their attention that they're violating your rights. Okay?
Okay. So but what I was saying is, even if I don't have the R on there, it is that person still have to figure out that it is trademark and not use it?
All because you're not using the R and your mark is registered, you can still assert your rights. It's not required for you to use the R. It is beneficial. It's beneficial to use the symbol with the R and the circle around it because it is a deterrent effect. It provides notice, but it's really the notice is to let them know, watch out, this is a strong mark, and its owners will take steps to protect it. It is a registered mark with the federal government. So take it serious.
Okay.
You tread at your own risk if you attempt to infringe upon this mark because it is a federally registered mark, and the owner has already taken active affirmative steps in protecting it by registering it with the federal government. It's not required for you to use the R with the circle around it, and some marks, even though they are registered just for stylistic purposes, still like to use the TM with a circle around it. It is a preference. You don't have to use the symbol. It is helpful because it provides a deterrent effect.
Okay. All right. Thank you so much.
Absolutely. Good question. Let's go with Larry. Forgive my pronunciation.
Hello.
Hello, how are you?
I'm good. It's Larry, but with an L. Thanks for trying. My question that came up, and I think someone answered it, answered it, but I know for sure that my name is used internationally. Mm-hmm. So when I thought to name my business what it is, of course, I did the search. I wasn't able to get the Google domain because another place in Singapore uses it, and we offer the same exact services. But from what you have been telling us, it's not so much the name, it's the mark. So that studio in Singapore and my studio can have the same name, but if my logo is different, then I can still register my logo.
I would say yes, absolutely. And I think there's rights. Now you're dealing with international law here, right? You're talking about Singapore. Mm-hmm. U.S. only has jurisdiction over the United States. International rights, when we talked about international treaties that you may have to avail yourself to. I think the World Intellectual Property Organization has some form of database that you can register your works for protection and signatories. It's all about agreements amongst the country when it comes to international intellectual property rights and even business violations. You could try to pull them into U.S. jurisdiction if there are minimal contacts with any jurisdiction within the United States. If they are targeting U.S. consumers and they are infringing on your mark, you can file a lawsuit in United States court and pull them into United States jurisdiction. It's a complicated issue. It gets involved with very large brands, but if you are a local business, chances are that a business in Singapore may not be impacting your business so much. It may not be creating confusion in the consuming public of the US. Does that make sense?
That does. Although when it comes to our websites, I had to add a name, a word to mine because I could not register it the way I wanted to because they had already registered it that way. Sometimes my students or potential students will find their website just one search above mine, and they'll describe it to me and I'll say, oh no, that's not mine. Go to the next search item that came up. So
it could be worth, again, policing. It could be worth asserting rights against them if it is detracting from your business, if it is creating confusion. You've just gave evidence of confusion. The consumers are visiting their website and not yours. Now they may be protected by different international jurisdictions. I don't know, but it may be worth policing by giving them a notice, requesting a cease and desist. And I would say this, when you're corresponding and you're making demands, legal demands, and you're asserting rights and you're claiming damages or you're saying that they owe you money, it's important to go under the cover of attorney letterhead, all right? Because when you start writing these type of correspondence, there's a thin line between asserting your legal rights and making legitimate legal demands and incurring liability for extortion. Is a thin line, and a lot of times you should go under the advice of counsel, and these type of communications should be provided under attorney letterhead, because attorneys a lot of times have privileges, litigation privilege, that they can make assertions with the knowledge that there may be pending litigation, whereas if you did it individually, you could incur personal liability. And also keep these type of communications A and B. Do not start sending these type copies of these type of correspondence, cease and desist, or notices of infringement to third parties. Do not do A, B, and C. Do not have a third party involved, because you can incur personal liability for interfering with business relations. And I like to keep things clean when it's these type of disputes. It's just unnecessary. I don't like to be in a position where now I have to defend from other claims of interference. We proceeded in good faith. It was only between A and B, and we didn't interfere with any relations. Does that make sense?
yes, it does. Okay, thank you.
Yeah. Any other questions? Let's go back to, I believe, Gwen.
Yes, hi. Can you hear me?
Yes.
Okay. I'm a consulting firm, and about 3 or 4 years ago, I hired a graphic artist to create a very unique artistic logo. And I was assured that from our research and from that work, I paid thousands of dollars for it. It was indeed unique. He, because of the way the graphic logo was created, layered several layers of information together. That's why we know it's very special, colors and all. And he went ahead and put a TM, small TM, for trademark at the end of the logo, because it would have cost a lot of money to add it later or what have you. So I want to do my website now. I want to use the logo. The name of my company is not unique. And the logo had to be created this way because of the name of my company. My company starts with A, B, C, and D, a consulting group. And because of that's why we created a logo such as I just described. Now, I haven't registered it, but there are two other questions. I thought that I could register what I do have with the state of my incorporation, with the trademark form that's with the state, in this case, the state of California. And also I wanted to do the state of Wyoming as well. But and I'm doing my website now, but if I use it on my website with the TM in, am I doing something illegally?
No.
Or should I pay money to have it taken out or go the copyright route? I'm just confused.
Good questions, and I understand the confusion. It's a overlapping area. I will say this: There's different databases. Yes, state database, state of California, state of Montana, I think you said. But the federal government trumps all. Federal government registration is the best. I would not personally even bother with state registration. Just file with the federal government. It trumps. And you're using it online, so there's argument to be made that you are in interstate commerce. You should register with the federal government. You will satisfy the interstate commerce by having it on the internet. Now, by having the TM, it's within your right to do so. You do not need registration to use the TM. I would encourage you to use the TM and put it on your website and use it in commerce, and ultimately file for federal trademark registration. Now, again, there's different databases. I will say this, more protection, the better. You really want to protect it maximum, file with the state Secretary of State with their database. Each state has a different type of regulation database. I'm not sure, there may even be some states that don't even keep a database for trademarks. Each state is different. Again, federal registration is more powerful. It would be sufficient to just register with the United States Patent and Trademark Office.
Okay, and to be thorough, I should have that done with a professional so that on a federal level, everything is done well. Because when I do, as I said, I'm a consulting firm in personal finance, and I do expect there to be nationwide activity, so I don't want to come up or be in a position of liability.
Absolutely, I agree. And I would always encourage you to seek the counsel of an attorney, even for registration. Whenever there are rights at issue, it's important that you're informed. And whenever rights are being protected or transacted, it's important that you speak to an attorney. Go ahead.
I'm sorry, and one additional adjunct to this question. As a corporation, I will have perhaps 4 major divisions with, again, the same trademark. And is that an issue or something to be considered in moving forward this way? Can I adapt and use that same logo on the other divisions, particularly if they get separated and sold off in the future?
Good question. And the last point was where I was going. It depends if all the ownership lies in you. But if you sell it off, then I would say you would need to have licensing agreements. Remember the formula. Rights equals power, which equals the ability to monetize. When you sell off your divisions, you want to make sure where the rights in your intellectual property lie. And you want to keep as many rights as possible. Rights is the power, and that's the ability to monetize. Many times when you enter into these type of agreements, act in rights, and you're not fully informed of how much rights or where the value is. Licensing agreements are very important. They should be drafted by an attorney. You bring up another issue that I also want to bring to your attention, because you contracted with someone to create this logo for you. It's important that you have your proper chain of title, which is a work made for hire agreement or an assignment of copyright from this artist. That's very important. The underlying rights, you need to prove that you have secured all the rights. You may have entered into a legitimate work made for hire agreement with this artist. I'm not sure. I'd have to dig a little bit deeper, and we can do a consultation on that, but that's beyond the scope of the presentation.
Yes, yes, I do own it and completely, but he's no longer even, actually, he's not alive anymore. I don't know what would be a substitute to prove that, but you'd have to advise me as to what I would do in that case.
Many different issues, and I have to encourage, if you have a very specific matter, to reach out to an attorney, because you brought up some issues regarding the decedent, the period of copyright protection, when does things fall into the public domain, work made for hire versus assignment. These are all very important legal issues, and that's why it's important to work with a competent attorney, and every person's situation falls on their own facts. That happens to be one with many legal issues. It goes a little bit further, I'd like to give another an opportunity to ask any questions. And again, I always do have to give the disclaimer, not legal advice, general information, entertainment value. If you have a specific legal matter, you have to speak to an attorney. The crux of the attorney-client relationship is confidentiality, the attorney-client privilege, the ability to listen and hear and hold secrets and advise the counsel of your client. That's the crux of an attorney-client relationship. Because we have third parties here and we are a nonprofit and it's going to be published, there is no attorney-client confidentiality here, and this is not meant to be for specific legal advice, just general education purposes. Evelyn, if you'd like to ask a question. See, you're on mute right now. Okay, we'll give it one more opportunity for anyone to raise their hand. With that being said, we're at the time mark. I want to thank everyone for attending. I really enjoyed this. And again, I want to say thank you to SCORE. SCORE has really helped me in my business journey, and it's a really great honor for an opportunity to give back. I'm very grateful. Thank you for everyone for listening.
Thank you, Justin Sterling. Thanks, everyone. Thank you.
All right, take care, take action. Have a beautiful day. Happy weekend.